What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Friday, March 21st. Lori Vallow has filed another motion to dismiss, and this time it is for violation of confidential communication and the Sixth Amendment. So let's read her filing. Defendant Lori Daybell hereby requests that this court order dismissal of both cases and sanctions on the state, Maricopa County Attorney's Office, and Maricopa County Sheriff's Office for violation of confidentiality and communications between attorney-client privilege. She cites Amendments 4, 5, 6, 8, 12, and 14, as well as the Federal Rules of Evidence 501-28, the Due Process Clause, and the Federal Rules of Evidence 502-28, that is attorney-client privilege and work product. The state is in possession of attorney-client privileged text message communications of another state, which federal violations are upheld. The Maricopa County Sheriff's Office Australia Facility Administration illegally obtained and provided attorney-client privileged text message communications to the Maricopa County Attorney's Office. Federal law requires that sanctions are imposed for remedial action of automatic dismissal of cases for judgment of acquittal, which the defendant is requesting. The defendant will show just cause to warrant sanctions and dismissal as follows. The first section is the facts. The defendant was extradited from the state of Idaho, where she will be returned to finish her sentences. The state of Arizona is only temporarily in possession of the defendant pending trial. The state of Arizona has no jurisdiction enforcing the state of Idaho laws or federal laws in another state to whom has first obtained and prosecuted the defendant. The state of Idaho upholds state and federal laws protecting attorney-client privilege as well as confidentiality and communications. This includes text messages between the defendant and her appeals attorney in Idaho, and such violation constitutes a breach of duty by both the Maricopa County Attorney's Office and the Maricopa County Sheriff's Office, since neither can employ Idaho laws in Arizona. Therefore, it is a violation of the state of Idaho and federal laws listed above. The defendant is in the appeals process in Idaho. The illegally obtained text messages between Craig Durham and the defendant are specific to work product and are federally protected in appeals court and federal court. Its contents include, but are not limited to, defense opinions, theories, and defense strategies. The agreement of both states was to preserve the defendant's due process, constitutional, and fundamental rights. The Maricopa County Sheriff's Office Australia Facility Administration willingly and knowingly violated the AID by providing the Maricopa County Attorney's Office the confidential communications between Idaho appellate attorney and the defendant, depriving the defendant's constitutional right to appeal her convictions. The Maricopa County Sheriff's Office violated all of the above by submission of the confidential communications to the court, creating multiple violations to the state of Idaho, federal laws, and the defendant's constitutional rights. The defendant's right to an appeal has been compromised because the text message contents refer to her defense strategies. The appeals court has no other remedial process but to dismiss the defendant's cases for violations directly related to illegally obtaining attorney-client privileged confidential communications by both state of Arizona and the state of Idaho. Evidence obtained through intercepting messages by a government agency are inadmissible because of the mode of obtaining is unethical. The rules of evidence in criminal cases in courts of the United States sitting there consequently are those of common law. The common law rule states that admissibility of evidence is not affected by the illegality of means by which it was obtained. Every person who shall intercept, read, or in any manner intercept or delay the sending of a message shall be guilty. The 18th Amendment has not in terms empowered Congress to authorize anyone to violate the criminal laws of a state, and she cites Olmstead versus the U.S. The state nor Maricopa County Sheriff's Office have been granted authority to obtain the communication records or text messages through judicial process, therefore violating the Brady Law. The federal laws prohibit both parties from obtaining a summons, subpoena, order, warrant, or consent to the attorney-client confidentiality communication privilege of another state, especially appeals attorneys. The sheriff's office and the attorney's office agreed this privilege would remain intact for the temporary custody of the Idaho inmate, Mrs. Daybell. The state provided the courts with intent and knowingly breached the interstate agreement contract, but breached both Idaho and Arizona fiduciary and judiciary duties with the Sheriff's Office Australia administration. The violations of both Attorney's Office and Sheriff's Office have compromised the integrity of the cases in Arizona and the appeal in the state of Idaho. The U.S. Supreme Court can and will dismiss or acquit the defendants' cases in both states. The U.S. Supreme Court can hold both judiciary court systems in violation of abuse of discretion. The Sheriff's Office and the Attorney's Office continue to violate state and federal laws by illegally obtaining, creating fruit of the poisonous tree doctrine violation, and Brady violations. The violations should be attached to the courts that allowed the above parties to submit the illegally obtained records, knowing the court never granted or awarded the state or the sheriff's office to obtain such records through an order, warrant, summons, subpoena, or consent. The court is aware that the breach is to federal laws and the laws of Idaho protecting client-attorney communication and privilege by allowing the submission to occur. Thus, violation of confidential communications with attorney work product cannot be compelled as shown above, compromising the defendant's appeal in Idaho. She cites, I may butcher this name, State versus Packard. Packard's motion to dismiss both state indictments claimed that Maricopa County Sheriff's Office had violated the defendant's rights under the Fifth and Fourth Amendments of the U.S. Constitution. Specifically, the Sheriff's Office, 1, illegally obtained the defendant's text messages, and 2, opened legal mail of the defendants deliberately and not in the presence of the defendant. The text messages and confidential communications that fall under attorney-client confidentiality and communications privilege were submitted by the state to the courts as evidence. Once the state reviewed the text messages provided by the sheriff's office, both parties should have sought an in-camera review. Neither the sheriff's office or the attorney's office adhered to the standard judicial process. 3. Neither party, the sheriff's office or the attorney's office, had in their possession a subpoena, warrant, order, consent, or summons to obtain the client-attorney privileged material or the work product, which cannot be compelled under Federal Rules of Evidence, Rule 501 and 502. Many of the intrusions are deliberate, calculated, and occurred while in custody. The sheriff's office's motive behind these instances is to deprive the defendant and legally assist the attorney's office in collusion. Their assumption was to mislead, misrepresent, and deceive the public, the courts, and the defendant that the attorney's office and the sheriff's office complied with state and federal laws in seizure, overlooking the fact that both parties breached judiciary, fiduciary, state, and federal rules of laws. Thus, a defendant's right include protection from improper instructions by the state and other governmental agencies or agents. See State versus Warner, because the sheriff's office and the attorney's office interfered with confidential attorney-client communications, has risk of disclosure of the confidential information. The intrusion chills free discussion between the defendant and her legal team. In State versus Sugar, The interference with confidential relationship destroys counsel's and legal team's effectiveness because effective defense can follow only when a defendant has made a full and frank disclosure of knowledge of events surrounding alleged crimes. Regarding the motive behind the seizure of the defendant's text messages, legal calls, legal visits, and legal mail, the use made of them, whether the interference with attorney or legal team relationship is deliberate, whether the state benefited in any way from the seizure, if the evidence is used to taint when purged in the defendant's cases, in fact, is prejudice. The attorney's office and sheriff's office purposefully read all correspondence that contains facts concerning the investigations of the offenses charged, the defense plans and strategies. The state has the burden to prove beyond a reasonable doubt that the interceptions is not prejudicial. The dismissal is required when the information intercepted is improperly used by the state. In such case, the state has so pervasively insinuated itself into the counsels of the defense, so it requires dismissal. In State versus Corey, sheriff's officers eavesdropping on private consultations between defendant and attorney vitiated the whole criminal proceeding and required dismissal. The government gained and exploited information from the seized evidence from the sheriff's office. Therefore, the inappropriate and unconstitutional conduct by both parties, the attorney's office and sheriff's office, warrants a dismissal with prejudice. Because the state submitted to the court the attorney-client privileged confidential communications, they are now public record. The state compromised the defendant's appeal in Idaho, breaching and violating state and federal laws in interstate collusion. The state of Idaho has public access to the submission by the state of Arizona in the appeal strategy, defense, opinion, and memoranda in the communication of the defendant and her Idaho attorney, Mr. Craig Durham. Furthermore, the state and the sheriff's office have not provided the subpoena to obtain the defendant's text messages. The Maricopa County Sheriff's Office Rules of Regulations and the Global Tel-Link Terms and Conditions argue that the texts are not privileged. The defendant contests that her communications obtained are privileged, citing specifically text turned over to the defense by the state on February 6, 2025. A text between defendant and Idaho attorney. In fact, they are privileged communications and non-discoverable as follows. Because the attorney, Craig Durham, legally represents the defendant in her appeal in Idaho, the defendant and her appeals attorney have made reasonable efforts to secure private and confidential communications to meet the expectations of judiciary process to continue in the defendant's appeal in Idaho. The defendant and her legal defense believe that all attorney-client communications are privileged and protected under the federal rules of evidence, Rules 501 and 502. The defendant has not waived or relinquished her attorney-client privilege to Mr. Craig Durham. Exhibit A is the communication emails from the sheriff's office to appellate attorney Craig Durham. At the time that attorney Craig Durham received this email confirmation that his communications with the client would now be privileged, defendant then presumed the same. Exhibit A also shows the extended timeline in which the appellate attorney had no access to communicate with the defendant and work on her appeal. The attorney-client privilege is derived from the defendant's constitutional right to due process of the 14th Amendment of the U.S. Constitution. See State versus Warner. The privilege is the essential function of communication between attorney and client. Unless the attorney knows the truth, he or she cannot be much assistance to the client. In Samaritan Found versus Goodfarb, if the accused is going to derive the full benefits of his right to counsel, she must have the assurance of confidentiality and privacy of communications with her attorney. The attorney-client privilege, as pertinent here, is codified as criminal action. In ARS Rules of Criminal Procedure, Rule 15.4, Upjohn versus the U.S., the work product privilege prohibits discovery of written statement, private memoranda, and personal recollections prepared or formed by counsel in the course of legal representation regarding Hickman versus Taylor. When a client's consent is not provided, the attorney may not disclose communications that the client made in the course of the legal representation. The proponent of the privilege will show that 1, there is an attorney-client relationship. 2, the communications were made to secure and provide legal advice. 3, the communication was made in confidence. And 4, the communications was treated as confidential. The attorney-client privilege extends to members of the Daybell's defense team, including her investigator, Jeff White, her paralegal, Idaho attorney Craig Durham for appeals, and her advisory counsel, Pamela Hicks and Robert Abernathy. The Clements element is to establish privilege that must be satisfied are the 3 remaining Clements elements. The communications are made secure, provided legal advice in confidence, and was treated as confidential. The defendant established a legal account on the tablet which she texted members of her defense team. The next section is events. On January 31st, 2025, Defendant's Advisory Council received an email from the state containing all of the defendant's text messages from the sheriff's office. Date range from October 24th, 2024 through January 24th, 2025. The text messages contained attorney-client privileged communications between the defendant, Lori Daybell, and her appellate attorney in Idaho, Craig Durham. On February 4th, 2025, and again on February 13th, legal mail addressed to the defendant from the Maricopa County Attorney's Office was delivered to the defendant previously opened by the sheriff's office staff, not in the presence of the defendant. Again, the legal mail was previously opened, not in the presence of the defendant, and then slid under the defendant's cell door in the middle of the night. February 15th, 2025 at 10:30 a.m., the defendant's investigator arrived at the sheriff's office and was sent away, being told he could not meet with the defendant that day, although he had important and time-sensitive documents to deliver to the defendant. On Monday, February 24th, 2025 at approximately 5:45 p.m., the Sheriff's Office Australia Administration, SRT, was sent specifically to the defendant's cell for a search. The defendant's legal documents were searched by SRT outside of her presence. There is both body camera footage and pod video surveillance that will confirm that the defendant was told to leave her cell and go downstairs during the search. Due to the fact the defendant has hundreds of legal documents and thousands of pages more of discovery, it is undetermined which documents were seized in the SRT search. The defendant was asked by SRT to look into her cell and identify immediately if any legal documents were missing after they performed their search outside of the defendant's presence, and this was impossible. On February 24th, 2025, legal mail from the defendant's appellate attorney in Idaho was again opened by sheriff's office staff and then slid under the defendant's cell door in the middle of the night, instead of it being opened in her presence and delivered to her personally. On March 6, 2025 and March 12th, legal mail was handed to the defendant previously opened by the sheriff's office staff, not in the presence of the defendant. When the defendant questioned the officer who handed the defendant the legal mail about the legal mail being opened without her being present, the officer stated that the legal mail was opened prior to him receiving and delivering it to the defendant. This is an ongoing issue. Clearly, the sheriff's office is not following their own policies and procedures when it comes to this particular defendant/inmate and how staff should be handling and delivering her legal mail. In conclusion, the state and the sheriff's office have violated so many of this defendant's constitutional rights. The state and the sheriff's office should receive sanctions for these egregious violations. The defense requests both cases dismissed, and this is dated March 18th, 2025. We are so close to trial, y'all. 10 days from today, jury selection. I will be out in Phoenix for openings and that first week of trial, and then I'll be back and forth. Also, I'm planning to do a couple of episodes, which will be a crash course on the Charles Vallow case. I've done some in the past, but we've learned new information since I did those. So I'm just going to redo those most likely next week at some point. All right, that's it for this episode. Hope you guys have a good rest of your afternoon, and we will see you soon.